Anything further?
No.
Justice Alito?
Well, if the Adjutant General is like the Secretary of the Army, let's say that there are certain Army employees who have the right to bargain collectively. Presumably, the Secretary of Defense could order the Secretary of the Army to engage in that bargaining personally, couldn't he?
So I think in that situation, and that was why I was trying to get at for what purposes the Chief Justice's question was asking for the comparison. For the purposes of bargaining comparison, DOD civilian employees have bargaining rights. Let's set aside these state dual status technicians. So just normal federal civilian employees of DOD have bargaining rights. But they usually bargain not with the head of DOD. They bargain because their units are set at lower levels with like the entity that controls their base or something.
No, they don't normally do it. But is there any reason why the Secretary of Defense couldn't say to the Secretary of the Army, I want you to do it? Or couldn't the President order that?
So I think two responses to that. First, yes, I think that could be ordered. But second, I think if the bargaining unit is certified at a lower level, which is what matters for the purposes of bargaining before the FLRA, that person wouldn't be the appropriate person to be engaging in bargaining. But of course, the President could order that person to actually go and engage on.
Well, what I'm getting at is if the Adjutant General is really a component of the Department of Defense, are there any limits on what the Secretary of Defense could order the Adjutant General to do in relation to collective bargaining?
So I don't think we've identified any limits. I think there are enforcement limits. If DOD were to instruct the Adjutant General to do something, the enforcement options that DOD would have would be pulling federal funding or federal recognition. They don't have the option to remove the Adjutant General from their state Adjutant General role, although they could remove him from his federal
role. They don't have the authority to order the removal of the Adjutant General. Could the Adjutant General be ordered to do what was broached at one point in this case, and that is to apologize personally to these employees for violating their rights?
So I don't think that an order along those lines would be distinct from the other types of orders that we've suggested. If there was a valid basis for that order and that instruction could come from DOD, but it would be limited to these enforcement options that DOD has.
This is a very unusual scheme, and what you're asking for may have implications. Why isn't the best solution to this problem that for Congress to step in and specify what is to be done in this situation, this arguably sui generis situation?
I think Congress already has said what it meant here, and I think the Savings Clause is one indication of that. 50 years of uninterrupted collective bargaining. 7 circuits had come out this way, and Congress has amended the Technicians Act multiple times in those 50 years. And I think there's every reason to believe that as long as petitioners accept the benefits of dual status technicians, which are free federal employees doing their day-to-day work, they have to accept the obligations that come along with that and have come along with it for the last 50 years.
Do you think that the Savings Clause represents congressional adoption of every administrative decision like the Thompson Field decision that was issued prior to that point?
I think it does indicate adoption of a precedential decision interpreting terms that are the same under the executive orders and the same under the Act, and that's what the Thompson Fields decision is.
How many such executive decisions or regulations would be covered by that?
I'm not sure, Justice Alito. I'm not sure how many precedential decisions there were.
Would it be a large number?
I think it would be at least in the hundreds.
And you think Congress surveyed all of those and said we want to freeze all of those?
I don't know what Congress was thinking, but I do know what Congress said in the text, and it was that such decisions would survive the Act's adoption.